Yo, what up, Lalians? That is he who inhabits the land of law and legitimacy. Welcome back. It's another year. I mean, I reckon years, not by New Year's Day, but by Labor Day. What can I tell you? And so a new year has begun. You know, I was sitting in the office yesterday working on a brief, got home while the sun was still shining, looked out the window and thought, my God, summer is ending and a new year begins tomorrow. And so it does. Oh, well, we've survived another. Today will be a big day in the Pretty Man Courthouse in Washington, D.C. The last and final sentencing will take place in the Proud Boys trial, and Judge Timothy J. Kelly will sentence Enrique Tarrio at a proceeding to take place at 2. By about 4, Nebuchadnezzar's handwriting will be on the wall, and we'll know what the sentencing is going to be. But I'm telling you, I can read it before it's written. I predict that Enrique Tarrio will pull a sentence of 20 years. Why do I say that? He was the leader of the pack, and Judge Kelly has sentenced the other members of the seditious conspiracy to 15 years for Zach Rell, 17 years Joe Bigg, 18 years for Ethan Nordine. Nordine and Biggs were similar in my view. It's interesting that Kelly ramped it up a touch on Nordine, but he'll sentence Tarrio as the leader to 20. And that will give him pride of place. Kelly will be able to say he imposed the most significant sentence of any of the J6 cases, and he did so against the leader of the most significant group, the Proud Boys. But it won't be a bit more than 20. And the reason for that is Kelly will try to protect his record on appeal. The sentencing guidelines in Enrique's case, in the absence of the terrorism enhancement, don't go all the way to 20. The terrorism enhancement that we've talked about at length here before to the sentencing guidelines will be applicable to Enrique, and the government will ask for a sentence of 360 years to life. Kelly won't do that, but he will give the maximum on seditious conspiracy, that is 20 years, and then say, I would have imposed this without the terrorism enhancement or the other enhancements. I have the discretion to depart or vary upwards, and I can do so up to the statutory max. And he will impose the other sentences concurrently. That's the worst possible sentence for Enrique because it's probably bulletproof as a matter of application of sentencing law on review on appeal. So you heard it here first, folks. Enrique pulls 20 today in the Proud Boys case. Again
on Rumble says Tarrio wasn't even in D.C. that day, and that is correct. He was not in D.C. 2021.
No, he wasn't. On January 4th, he was arrested for other events and told to get out of town, and he did. But from the government's perspective, he was a co-conspirator who was monitoring and directing events from afar, and Kelly will not give him a discount for not even being there. I hear you over there. Who is that on Rumble?
It's me again, Sai.
Yeah, I hear you. It's me again. It's a powerful argument. His lawyers made it throughout the case, and Kelly rejected it, as did the jury. So stay tuned. We won't go on too much more about it today. I'm sure I'll have more to say about it tomorrow, depending on how events unfold today. Yeah, R.I.P. Margaritaville. This one bugged me. I mean, live long enough and everybody dies. I get that. I'm at an age where I go to more funerals than I do weddings. But even so, losing icons is losing part of yourself. I don't know if there's a Margaritaville in the afterlife. If there is, Jimmy, this one's for you. A positive, upbeat presence apparently battled for the last 3 or 4 years a form of skin cancer that led him to meet his end. I think he was 75. It was a long run. Obviously, the closer you get to 70, the younger 75 sounds. For those of you in your 30s and 40s, hey, what's the big deal? He had a long life. And you know, Socrates once said the goal is not to live, but to live well. I don't want to stretch every year that I can out of this train wreck of a body of mine. But it still is sad to see a good man go. So what's going on in the big world, Mike?
Man, we've got a big day today. Right? It's draft day for Ball and Legitimacy. So all of you who are in the league, we got a full league of 12 members. We are drafting promptly at 12:15 p.m. Eastern on the ESPN platform. Make sure if you're not able to get to a desktop that you have the app downloaded on your phone. Norm, I know you'll be playing it close today, and you'll attempt to get back to your laptop ASAP. But we're trying to get this done over the lunch hour. Really looking forward to it. we're also planning some companion content so that those who really just want to hear Norm and me talk about the law don't have to be burdened with sports talk too much. So Matt and Jason, thank you guys for taking the lead on that. High Society on the Rumble chat. For those of you who don't know that, that's Jason. He's taken the initiative along with Matthew Kyle, and he tends to be over here on YouTube. So they will be championing.
Knowing Matt, he's probably at home going over his drat stats so that he can like slay us. This is a guy who just by chance will end up with Kurt Mahomes and Jalen Hurt and the top running back and the top defense, and I don't know how that happened. He's got it all planned.
Bathtub Liquor wants to know if you're going to be drafting during court. I'm pushing for it, BTL. I mean, look, this is the era of remote court anyway, so I don't know what Norm is doing pretending that he's actually there,
I've got my hands full in court this morning. I've got 3 cases down. One is a murder, one is a fairly vicious assault, and the other is a pretty grim child pornography case. So, I will go and deal with the clients and their questions and the state and their issues and the judges and their problems, and then I'll get the hell out of there and come back to the office and hopefully do my draft. So,
I think my team name is finally settled. I've been back and forth on several, but in honor of one Brees Hall, my official name for Ball and Legitimacy is Amicus Brees. I thought that was pretty good.
Oh, that works. Hey, let's talk about Fannie Willis and a potential new Georgia law that would create a prosecuting attorney oversight committee. Can that law? What would the law do? Does it have a realistic chance of being passed soon? And does it retroactively apply if it?
Yeah, the law is already went into effect it was passed July 1st, and then and it goes effective October 1st. So that's the first day that complaining parties can submit complaints to what is going to be known as the Prosecuting Attorneys Oversight Commission, which is an 8-member commission. And the members, I've got it here on the screen, are able to do a number of different things, but by and large, the focus of this is giving that commission the authority under certain circumstances to remove validly elected prosecutors from their positions. And so we're talking about matters of abuse of discretion, things that bring the practice into disrepute, sort of vague appeals to that. I think when it comes to Fulton County District Attorney Fannie Willis, what I perceive to be the I guess the most valid scrutiny, justifiable scrutiny of the case is the inclusion, beyond what appears to be pretty obviously or facially politically motivated. I think with respect to why other attorneys would be willing to indulge a conversation about the creation of this commission is the inclusion of Trump's attorneys as criminal defendants.
That is pretty chilling. I mean, and I've seen Harmeet Dillon and Ron Coleman's wife raise interesting questions about this issue. And Harmeet is very vocal. She's never seen anything like it in her life. I have seen lawyers prosecuted for the advice that they give to their client, because lawyers, like everyone else, can be criminals. They can break the law. And if you advise your client to break the law, well, your client goes out to break the law, the two of you got some splaining to do, and it's likely to be to a jury. But there is this question of the political question doctrine. There is this question of the outer limits of what is acceptable political advice. And I recall in the run-up to January 6th, in the months that preceded January 6th, trying to calm any number of people down by saying, look, he and his lawyers are entitled to explore every legal avenue that they have. They're not required to be right in what motivates them in their assessment of the electoral context. And so with respect to the prosecution of John Eastman, for example, I think that's a particularly shocking prosecution. He advised Trump on theories that even if they were losing legal theories, he put his professional license on the line and said, Mr. President, you might want to pursue this theory. You might want to pursue that theory. They went to court and they lost. That doesn't make him a criminal, Fannie. What happens if Fannie, here's an open question to you. If a lawyer gets it wrong, are they a criminal? So if Trump gets acquitted, are you going to jail? No, lawyers apply the law to the facts as they understand them, and then they make judgments, usually analogical judgments based in analogy about whether the given law, the law of in a particular area, covers a case. With respect to the practice of law, lawyers, as Oliver Wendell Holmes Jr. once famously put it, that a lawyer's job is to counsel a client to bargain within the law's shadow. In other words, when a lawyer passes the bar exam, they become minimally competent to give advice to people about what shadows the law casts over the community. And if a person says, "Can I do X?" the lawyer says, "Well, be careful. You can do X, but not Y." And the First Amendment guarantees us freedom of speech and political speech, and it guarantees us the right to be wrong. And so a state prosecutor prosecuting a federal official for giving legal advice that the state prosecutor finds wrong, that's just chilling. And that suggests that the prosecution should be removed, at least as to the lawyers, to federal court, where we might get a more serious and a more mature application of federal law.
Yeah, I mean, I struggle with the overall of this from a because I'm an attorney that practices in the business and regulatory space, and I deal with commissions that are given a mandate that most often they never fulfill. I look at something like SB 92 in this instance, and my question is ultimately, well, when will this body have fulfilled its mission and its duty? Because it appears to me that it's sort of an indefinite mandate, that this is just the prosecuting attorney's oversight commission, and there's 8 members, and they'll probably appoint mostly attorneys. Right now, I think that there have been three attorneys appointed to this 8-member panel. All of them are district attorneys. But the issue is pretty simple. I mean, practitioners understand that law is a self-governing, self-regulating profession, right? There is a state bar in every state to which complaints are drawn or submitted, and ethics issues are adjudicated that way. I also, on the other hand, understand that the judicial process has been politicized to an unrecognizable degree, and so what is the answer to that issue? I
don't think this board is the answer, candidly, because
I don't either.
You look at attorney grievance processes and attorney grievance panels, and it's an insider's game. Usually, we say the law is a self-governing profession. It takes a lot to get disbarred. Most often lawyers reviewing lawyers will give lawyers the benefit of the doubt. In this case, there are, as the portion of the article you highlighted suggests, powerful separation of powers issues.
Yes.
Here. I mean, Fannie is a separate, independent constitutional agent. She's got the right to make decisions, and she's got the right to be wrong, just like Trump's lawyers do. So the irony here is that, I'm no fan of Fannie, no pun intended. I don't want to be accused of being a fan of Fannie when she fans her eyebrows in that fantastic way that Fannie has. But yet she has a right to occupy her office, as did Eastman, as did Cheeseman, as did Mark Meadows, and to apply the law as she sees fit to the requirements of justice. I don't think she should easily be removed. On the other hand, I don't think these men should be easily prosecuted.
Right. That's sort of that's why this is such a difficult issue to grapple with, because the mechanism by which this is being achieved is entirely artificial, right? And I think that as a profession, law would love for the culture of law to be able to rest atop its own morals and principles, and for attorneys to do their job, right? But in the case of Fulton County and DeKalb County, together, we've been over the Georgia election results in 2020. We've looked at the rest of the state of Georgia on a county by county basis. When you contrast what you see in terms of violent crime rates, sort of deferred prosecutions, lesser prosecutions, but then at the same time, a district attorney's office that has as a key priority charging and going to trial against the leading Republican candidate for president of the United States and Donald J. Trump, and as well as his attorneys within that criminal conspiracy framework. It's just really, it's tough to reconcile that perhaps there does need to be a more I guess, foundational shift in the way that law is going, because this is a disenfranchisement of voters across the board. Anytime, and I'm not trying to be partisan by saying that, but if even if Fani Willis is duly elected, this board has the ability to undo an election by the people. Now, again, conduct after an election can achieve that, right? That can be a basis for being removed via impeachment. But this is an additional mechanism, Norm. And so I think that, I don't know. I think that this lawsuit challenging the law is probably going to be successful on one or more of the ground, as First Amendment, due process.
It's an important lawsuit. And and let's contrast this with something we hadn't agreed to talk about today, but we missed last week. We were going to talk once again about the Section 3 of the 14th Amendment argument against putting Trump on the ballot. That argument is surfacing around the country right now in response to the law review article published earlier this year. The argument being that because Trump engaged in sedition or lended aid and comfort to those who were involved in insurrection against the authority of the United States, he's therefore disqualified from office. And the authors of the article said that was a self-enforcing provision of the Constitution, transferring thus a duty to each elected official who's taken an oath to uphold the Constitution, the responsibility for keeping Trump off the ballot because he engaged in this conduct. Alan Dershowitz has been writing a powerful pieces of rhetoric, which he might have been inspired to write from us because we called it here first, saying, hey, wait a minute. He's entitled, the president is, to some judicial process. We don't want town clerks deciding not to take his papers to put him on the ballot or to approve campaign events in their community if such approval is necessary because the town clerk think he engaged in insurrection. In the same way, we don't want other officials saying, Fani, we disagree with your decisions, therefore we're going to remove you from office. This crisis of legitimacy that the country is enduring seems to be eating its way as some sort of insidious cancer into our institutions, where we're now empowering everyone to declare what the law is and what the Constitution says. And the result of this is going to be utter chaos. Institutions matter. Respect for institutions matter. Respect for the Constitution matters. So I would say, as to Fani, let's go slow. As to town and state officials who are going to be inclined to decide they know what the 14th Amendment requires, we're not going to put Trump on the ballot. We're going to make him sue us to get on the ballot. Why isn't that a form of electoral interference that requires prosecution? And once you start spinning down that rabbit hole, it's turtles all the way down. And so it's a scary world out there right now, and it's going to get worse, folks, by the time the 2024 election rolls around. And so enough said on that. Hey, what's going on with Elon?
Well, I think I sent you something last night, and I think that may be the wrong. Here it is. I sent you a few tweets from him last night, and it was him tweeting, and I'll bring it up. Quote, "To clear our platform's name on the matter of anti-Semitism, it looks like we have no choice but to file a defamation lawsuit against the Anti-Defamation League. Oh, the irony." And someone responded on X saying, wouldn't be the first time the Defamation League would be found to have defamed people. And Elon responded to that saying, interesting. In our case, they would potentially be on the hook for destroying half the value of the company. So roughly $22 billion. One more. Someone responded to that saying, I've not seen anything related to this up until recently. Are they alone seriously responsible for destroying half the value of the company? I won't ask for details, lawyers and all, but I'm very interested to find out what the heck has been going on when the time comes. To which Elon responds, based on what we've heard from advertisers, ADL seems to be responsible for most of our revenue lost. Giving the maximum benefit of the doubt, I don't see any scenario where they're responsible for less than 10% of the value destruction, so roughly $4 billion. Document discovery of all communications between the ADL and advertisers will tell the full story.
So defamation is obviously an exception to the First Amendment. You have a right to freedom of speech. The First Amendment says Congress shall make no law, but the courts have interpreted the ability of themselves and legislators to create some torts, some private causes of action against individuals for their speech, and among them is defamation. There's defamation per se, that is where you don't need to prove damages. What you've said about a person is so shocking. Your mother is a murderer and she's not. And then there's defamation that harms a person's reputation, or harms their prospects, and causes them discernible or ascertainable economic loss in the marketplace. The ADL, I once sued the ADL for defamation on behalf of a client. They were quick to accuse a client of being an anti-Semite. The comment was not anti-Semitic, at least in the client's view and in our view. So we sued the ADL, and the case settled to the satisfaction of the parties. I'm not permitted to say more under the settlement agreement. But what I learned is, the ACL is a powerful adversary. They take the never again approach. Meaning, in the run-up to the Holocaust in the Second World War, there was every sign, every indication to believe that Nazi Germany was turning in the horrendous way that it did, a way that resulted in the destruction of Jewish communities throughout Central Europe, and the murder of 6 million people by the Nazi regime. And so the ADL takes a zero tolerance. The result of that is they often get it wrong. The result of that is they'll come out swinging, and they'll see anti-Semitism in the face of ambiguity, and in the desire to root it out before it can blossom. They will often say things about a person that is wrong. And in Elon's case, if they've accused him of anti-Semitism, when all he's doing is promoting freedom of speech, that is attributing to him a motive that he doesn't have. And if he can show to the satisfaction of a fact finder that a false accusation of hateful conduct, that is being anti-Semitic, harmed his company, then the ADL should be on the hook. And so this is far from a frivolous lawsuit, potentially on Mr. Musk's behalf. There is precedent for it around the country. The ADL has been sued, and sued successfully, for defamation, and it is ironic. So we'll keep an eye on that.
Yeah, I mean, so in addition to defamation, this is a clear case of tortious interference with business relationships. Talking about advertisers means that there were existing relationships with Twitter, between Twitter and third parties. Elon acquires Twitter in full. Those relationships, by and through the purchase and sale documents, would have gone with the company. And when the change to X occurred, and pressure began mounting yet again for various policy changes and We've talked about the appointment of Linda Yaccarino to CEO. There's Elon. Elon is under tremendous scrutiny from both sides of the partisan political aisle. Right, those who lean to the political right are very skeptical of Linda Yaccarino and her awful but lawful, and then sort of the freedom of reach, or the freedom of speech versus freedom of reach paradigm that seems to be emerging online, and with respect to First Amendment freedom of speech. And then on the other side, you've got the political left that seems to really use the arguments of anti-Semitism highly selectively, right? Because the political left in the modern era is quite hostile to the Jewish community in many respects, right? Especially from a geopolitical perspective. But the ADL in particular seems to use this as a veneer, a very powerful veneer, to force people to comply. We talked about the Ye controversies a while back. We had Ron Coleman come on the stream to discuss why it is that this is such a powerful allegation to make, the allegations of anti-Semitism. But Elon posted on his timeline yesterday several articles. The first one I have on the screen here, he says that Facebook caved to the far left pressure groups and now allows them to silently dictate policy in exchange for ad money. This is sort of a hostage situation, is what he's implying.
ESG on steroids,
right? And then look, he says, interesting documentary, and this is from NPR, exploring the politics of quote unquote defamation. Another interesting article from tabletopmag.com. The mind-bendingly insane, completely craven, utterly unconscionable, blah, 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 right? So in the premise of that article is that the ADL is as bad as they are advertised. right? So all of these things he has, and for public consumption, and you can see on the Facebook article 19.1 million impressions, on the NPR article 14.3 million impressions, on the tabletmag.com article 10.6 million impressions. He's building a legitimate case for himself in the public sphere, and he's going to match that in the civil court system. So we'll keep track of this, but I'm hopeful that his independence, and we cannot forget, this is not an isolation, Norm. I know that I'm rambling here. This isn't an isolation. SpaceX is now under investigation for some sort of employment discrimination practices by the federal DOJ, right? And so there's a pressure mounting over here. The speech issue on X as we head into an election year is going to continue to heighten. I don't things exist in isolation, although that does leave some question as to the causal link between. But as we have just learned in the seditious conspiracy trial of the Proud Boys, there needn't be an explicit conspiracy between people. They can just decide in an instant that they're all going to conspire to some outcome, right, Norm? I'm just I'm being tongue in cheek with that, but there is an effort to undermine the one source of information and communication that appears not to be controlled in the way that Facebook and Instagram are controlled, or establishment media outlets are controlled. So I'll leave it at that. I'm really interested to track this, though.
Yeah, I'll be fascinated to see. I just remember our case was relatively low stakes by comparison to Elon's ownership of X and the kind of money he's talking about. But it was plenty devastating to the client, who was crushed by the accusations in their community. And yet, when it came time to have confidential settlement discussions, the ADL came loaded for bear. And as far as they were concerned, this was an historic struggle, and this had to be stopped immediately. And I got a sense of the fury of righteousness and the sense of entitlement associated with it, and the willingness to police speech and the willingness to hurt ordinary people if they cross boundaries that the ADL didn't want crossed. Speaking of boundaries, tell us more about Edward Blum. Who is Edward Blum?
Yeah, I'm so this came across my desk, so to speak, this morning. So the one of the attorneys that was principally responsible for the Students for Fair Admissions lawsuits against Harvard and UNC Chapel Hill, respectively, that just ended with the unconstitutional ruling with respect to
the ruling that affirmative action is unconstitutional.
Correct.
Was not an unconstitutional ruling.
No. Yeah. So with the ruling that affirmative action is unconstitutional, thank you, Norm, for the clarity. Yet he has now set his sights on what I call big law, right? So Perkins Coie, and I'm neglecting the other law firm here. It's an international firm, Morrison and Forrester. I'm not sure if you're familiar with those. But he's launched 2 lawsuits, and so this is a private sector effort to root out affirmative action within big law, right? Those firms that are putting together scholarships, intern programs, and job offers and employment practices that are designed to exclude anyone who is not within a marginalized group. Right. And
who is financing American Alliance for Equal Rights? I mean, I think I'm going to sue one of the world's largest law firms. Gulp, I mean, these people don't count their money; they weigh it in a back room.
Well, and if I'm not mistaken, isn't Perkins Coie have they not represented Hillary Clinton for quite a long time? I could be speaking
octane rich for me. I don't represent people that don't have blood on their hands usually. So Perkins Coie is a little too white shoe for me.
Well, so there's this one, and then there is also, so the first one I have on the screen here is out of Texas. This other one is actually out of Florida. So the one against Morrison and Forrester. So
good forum choices for him. So
I think so as well. But you can see from the face of the complaints that this is mostly about affirmative action in practice. So whether they call these things affirmative action within the hiring practices or the scholarship programs or the internship programs, the exclusion of certain groups on the basis of race is within the crosshairs. So I'm interested to watch what Bloom does with these.
I'd love to get him on for a long form
I
interview.
would too. I would really,
as well as Alan Dershowitz. I know Alan's too busy to listen to us, but I'd love to get him on as well if he's interesting. And his embrace of the New York Sun, a newspaper that I'm encouraging everybody to take a look at, is particularly refreshing. Hey, Mike, I think we got a hard stop today. I got to get to court. You've got obligations, and we have a draft to attend to in about 4 hours. But
yeah, we do. So just, for those, thank you everybody for tuning in. Norm and I both have to get out of here, sort of on a hard stop today, but you know how to find us every day, 8 a.m. Eastern time on Rumble, YouTube Live, and on X at LawPod Daily. Please follow and share, like, subscribe, do those various things that help raise our profile and continue bringing you stories and analysis from the legal side of things. So Imperious is pretty cynical this morning, which I understand why. But again, just to say that for everybody in Ball and Legitimacy's inaugural season, 12:15 p.m. Platform is ESPN. Everybody's already gotten in there, so just be there or be.
Yeah, I lost you there, Mike.
Oh, sorry.
Well, 12:15 p.m. and we'll be back tomorrow morning at 8 a.m. I'm not sure if you guys can hear me, if it's just Mike that froze up. Thanks for listening. Leave us a 5-star review or leave us alone.
Absolutely. See you tomorrow, Norm.
Bye.